The South Carolina Supreme Court has now taken up the appeal by Alex Murdaugh's legal team, and this appeal has just to do with jury tampering. That's the only thing that it has to do with. So to understand, again, procedurally where we are at this stage, here we go. Let me just set the stage for where we are procedurally, and then I'm going to get into more of the substance of the actual appeal. Now, I do want to say that if you've been following some of the other outlets, some of the other channels, I'm noticing that people are making a very big mistake. So I'm here to help correct the mistake and help everybody really understand really what the issue is and where we are now. All right. So what's going on is the following. We know that Alex Murdaugh was found guilty. Then there was a regular appeal that was filed with all the different types of issues why he should get a new trial and some taking up some of the rulings, a general appeal, which we find in a lot of cases. That appeal is now sitting at the Court of Appeals level. So you have the trial court level, then you have the Court of Appeals level, and above that you have the Supreme Court level. All right. Now, also, let's remember this is in the state system. There's two systems, two court systems. There's the state system and there's the federal system. So he was tried. He had some federal crimes also, but for the murder, he was tried in the state system. Now, in the state system, they filed an appeal with all the arguments about the different reasons why the trial wasn't fair or some rulings weren't fair and he should get a new trial. That was at the Court of Appeals level. Then they found out about some potential jury tampering by the court clerk, Becky Hill. So what they did was they filed a motion to stay the appeal because once jurisdiction transfers, now the Court of Appeals is the court that has jurisdiction. You can't just go file something in the trial court level without letting the Court of Appeals know what you're doing and to get essentially permission to do that. So what they did was they went to the Court of Appeals and they did a motion to stay the appeal, which means let's just pause everything and send the case back to the trial court level and the lower level. And then let us file a motion for a new trial based on jury tampering. So that's what happened. The Court of Appeals stayed the appeal. They sent it back to the trial court level. And in the trial court level, they appointed there's a new judge that was appointed. In the meantime, they also went to the Supreme Court for a writ of prohibition. Okay, eventually they got a new judge appointed, Judge Toll. Now, Judge Toll was the judge who presided over the evidentiary hearing where Becky Hill was called and all the jurors were called and asked certain questions. And Judge Toll was the one who presided over all those proceedings. Judge Toll's findings was that there's no basis for a new trial. Yes, Becky Hill maybe made some inappropriate comments, but there is no basis for a new trial. We're going to be jumping into more of the substance a little bit later. Right now, I'm just trying to set the stage procedurally where we are. So now what happened was, now the Judge Toll ruled that there's no basis for a new trial based on jury tampering. So now there's a second appeal, right? There was the first appeal, which is after the conviction. And now there's a second appeal with respect to the jury tampering, with the ruling that Judge Toll made regarding the jury tampering. So now that went to the Court of Appeals. So now you have two appeals that are sitting at the Court of Appeals. The first appeal, which is based on just all the rulings in court and some of the issues that came up, whether the financial stuff was allowed to be admitted, things like that. And now you have a second appeal, which just has to do with the jury tampering. Then what happened was the Alex Murdaugh legal team said, this issue should go to the Supreme Court. And we should really skip the level of the Court of Appeals. Now, generally speaking, you're not allowed to skip levels. You have to go each level at a time. You start at the trial court level, you go to the Court of Appeals, then you go to the Supreme Court. That's how it works. So what's this business of just skipping the Court of Appeals level and going straight to the state Supreme Court? Well, there are instances in which you can do that. And this was the argument that they made to the Supreme Court. They filed the papers that are necessary to get in front of the Supreme Court and say, the Supreme Court, should take over this specific issue with respect to the jury tampering. All right. So the Supreme Court agreed with the Alex Murdaugh legal team that in this specific appeal, which just has to do with the jury tampering, we are going to allow that the Murdaugh team can skip the Court of Appeals level and go to the Supreme Court level. All right, so now what we have now, just to kind of set the stage, we've got this appeal with respect to the jury tampering that's sitting now, that's going to be heard by the Supreme Court of South Carolina. We have his first appeal, which is still down and stayed at the Court of Appeals level, most likely. And we're just going to now concentrate on the jury tampering issue, which is going to go in front of the Supreme Court of South Carolina. Now, the brief was already filed. There's Alex Murdaugh's legal team. They already filed the brief at the Court of Appeals level. And now the Supreme Court said, okay, you can now file your brief within 30 days. They're most likely just going to copy and paste the same exact brief and just change the caption that now we're in front of the Supreme Court instead of the Court of Appeals. All right. So that is essentially where we are now. So again, we have to now understand the law when it comes to jury tampering to see if there's any basis for this appeal. Is there any basis to reverse Judge Toll? All right. Now, if you've been following this channel all along the whole jury tampering allegations, you may remember we did a deep dive on the case law. We really went through a lot of the cases in depth to really understand. But again, we're going to recap everything for this video so you'll all be in a perfect position to really understand what should happen in this case. All right. So let's start with the United States versus Remmer decision, because everyone's talking about Remmer. And now there have been some reports that this appeal is really seeking that they want to change the law in South Carolina, that it should align with the federal law, right? That's what some of the reports have been about this case, which is absolutely wrong, by the way. So this is part of what I'm trying to correct here. Again, some of the reports have been that this appeal seeks to change the law in South Carolina, change the state law, and for the law to be more similar to the federal law. As we know, there's a federal system and federal case law, and then there's also the state system, and each state has their own statutes and laws that can be determined by the courts and the Supreme Court. So there's always two different systems. Alex Murdaugh was charged for murder and tried in the state system. So they used, and Judge Toll said that she was using state law. Now, again, the reports have been that this appeal seeks to change the law in South Carolina, the state law, to change the state law so that it can now conform with the federal law. Okay, that is incorrect. That just means you don't understand really what the cases actually say. Now, of course, if you've been following this channel, you already knew that, but we're going to explain to you why that's actually not really what's going on, which is why a lot of the reports are just wrong. So let's, again, remind ourselves what the law is with respect to with jury tampering in the federal system and what it is in South Carolina. All right. In the federal system, we have United States versus Remmer. That's the United States Supreme Court case. In United States versus Remmer, the Supreme Court, the United States Supreme Court, found the following. This is what they held. They held that if there is any sort of contact, any sort of conversation between a court official and a juror, it is presumptively prejudicial, meaning we assume that if there is any conversation between any sort of court official and a juror, that means that we have to assume the presumption is that it was prejudicial. And then the burden is on the government. The burden is on the prosecution or the state to prove that that conversation or that contact was not prejudicial. It was harmless. Okay, so let's just understand that. Who is the burden on? Is the burden on the state or is the burden on the defendant? So under United States versus Remmer, this is clear as a bell. In United States versus Remmer, all the defendant has to prove is that there was a contact. There was some sort of contact between a court official and a juror. That's all they have to show. Once they show that there was some sort of conversation or some sort of contact, now the burden's on the government to prove or to show that that contact was not prejudicial. All right. So that's United States versus Remmer. Okay. So that's pretty simple, pretty understandable. But then what happened is that there was some other cases that came down from the United States Supreme Court, which seemed to say something different. And the perfect example of this case is called the case of Smith versus Phillips. Smith versus Phillips said that not only does the defendant have to show that there was some sort of contact or some sort of conversation between a court official and a juror, but the defendant also has to show, he has to prove that that conversation actually biased him. He has to prove that there was actual bias. Well, that is a lot harder for the defendant to prove that there was actual bias that was injected into the jury deliberations because of that contact. Okay, so it's much more strict, much harder on the defendant under Smith versus Phillips. Now, very clearly not the same as United States versus Radner. And I explained this. I explained in other videos that if you try to distinguish, if you try to argue that really Smith versus Phillips and United States versus Radner stand for the same thing, and just the facts of Smith versus Phillips was different than United States versus Radner, and really they all agree, you are going nowhere in a hurry. It's just not going to work. It's too clear. Smith versus Phillips is clear that the defendant has to show and prove actual bias. And it's clear for United States versus Radner that the defendant does not have to do that. And there's a great case. This is actually a case in Massachusetts. United States versus no, it's not United States. I think it's the state versus Barreros. And in that case, it really goes through the entirety of the federal cases that came out with respect to this issue, showing that there's a very clear split. There is a split in the United States Supreme Court itself. In some cases, it went with United States versus Radner. And in some cases, it went with Smith versus Phillips. So there is a very clear split. So what do? What should a court do? Now, again, we're still in the federal system. So let's just concentrate federally what we should do. What should a federal court that's not the United States Supreme Court, what should they do when they have a jury tampering issue? Should they follow United States versus Radner, or should they follow Smith versus Phillips? So this is where the circuits are split. The federal circuits are split. What should, with jury tampering, follow United States versus Radner, or do we follow Smith versus Phillips? But nobody says that really they say the same thing, and it's just you can try to distinguish them. It's an argument that's just not going to work. Anyone who is definitely a legal scholar is not going to fall for it. So it's not an argument to be made. Fortunately, in some of the papers, I saw this argument being trying to be made by the Alex Murdaugh the team, and I think it's a big mistake. So let's move on. What should a federal circuit do? Well, it depends. Different circuits do things differently. But the Fourth Circuit, which includes, the way it works in the federal system is that in one circuit, a number of different states are in the same circuit. So in the Fourth Circuit, that is where South Carolina is. And the Fourth Circuit said that you go with United States versus Radner, you don't go with Smith versus Phillips. Okay, so it's very clear from the Fourth Circuit, they're following United States versus Radner, which is much easier on the defendant to show. All they have to show is that there was some sort of contact or conversation between the court official and the juror. All right. But now we're still in the federal system. So this is all federal. What does it have to do with the state? We're in the state system. In the Murdaugh case, you're in the state system. So what do? Well, you got to look to the Supreme Court of the state of South Carolina. See if they've ever had any sort of jury tampering issue. Well, guess what? They did. They did have this issue. It actually was a case called State versus Green. State versus Green, and that is the South Carolina Supreme Court where they're weighing in on what the procedure is when there is jury tampering. What are they going to do? Are they going to follow Radner? Are they going to follow Smith versus Phillips? That is the question. So without any further ado, I'm going to show you what Judge Toll said, what her opinion is about what State versus Green says. And then we're going to jump into what State versus Green actually says. But first, let's give Judge Toll a chance and see what she has to say. So here we go.
Here's my position on the matter. First of all, I am not conducting a Radner hearing. Radner is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence.
So there you have it. She is saying very clearly, Justice Toll, that even though you're right that there is this decision called the United States versus Remmer, but State versus Green clearly says that we do not follow Remmer. Which case would they follow? Smith versus Phillips, which would mean that the defendant in this case, Alex Murdaugh, would have to prove that there was actual bias was injected. That's his burden to prove, not just that there's a conversation or a contact, but there was actual bias. So that was the basis for Judge Toll's ruling. She's following State versus Green, and since State versus Green says we do not follow Remmer, so we're not going to follow Remmer, and therefore the defendant has to prove actual bias. Now, so let's just take this to its logical conclusion. So then we had the hearing, and we had Becky Hill on the stand. We heard the juror. One of the jurors very clearly said that Becky Hill told her to watch his body language and watch how he's going to testify and pay attention, and things which she understood, the juror understood, that Becky Hill was trying to convince her that Alex Murdaugh is guilty. So that did come out. But according to Justice Toll, Murdaugh's team failed to prove that actually biased her. And we're going to get a little bit more to that a little bit later, but let's just understand which holding she's using, which basis of the law she's using in order to analyze the proceedings, right? You have to know what the law is. And according to Justice Toll, State versus Green says clearly that the law is in South Carolina that the defendant has to prove actual bias. We do not go with United States versus Remmer. Well, let's see what State versus Green says, and then we're going to see how this argument is made actually in the appellant in Alex Murdaugh's legal team's moving papers. So let me just pull it up right here for you. All right. So in order to understand what's going on with Remmer, you have to understand that Remmer first went, as we explained, that you have to go step by step. So Remmer first started off in the Court of Appeals. Then it got appealed to the Supreme Court. Okay. Now, if you just look, this is just a lesson for everybody out there. If you just look at a Supreme Court decision without looking at the Court of Appeals decision, you could be misunderstanding a lot of what the Supreme Court is doing. It's like starting, if you want to read a book, you're not going to start from chapter 30 and on. If you really want to understand the book, and you really want to understand actually chapter 31 through, let's say, chapter 50, if you really want to understand those chapters, you really got to understand what was written before that, right? That's pretty simple, basic. So if you really want to understand completely what the Supreme Court in State versus Green holds, you have to really understand first what the Court of Appeals said about it, and then move on to the Supreme Court decision and see what they're changing about it. So you got to start with the Court of Appeals decision in State versus Green, which is what we're going to do right here. And we're not going to go through the entire decision, but this is what happened in State versus Green. And this is the ruling. Okay, so here we go. In the event, and I highlighted it for you, in the event the trial court learns of an allegedly improper contact with a juror, the procedure of Remmer versus United States must be followed. So very clearly, in State versus Green, the Court of Appeals is saying that the procedure of Remmer versus United States must be followed. It's not an option. It's not, you can either use Remmer or Smith versus Phillips. We are completely, wholeheartedly adopting Remmer versus United States. That's exactly what it says in the Court of Appeals. And this is what they quote Remmer as saying. In the criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is for obvious reasons deemed presumptively prejudicial, if not made in the pursuance of known rules of the instructions and directions of the court parties. Okay, now the presumption is not conclusive, of course, but the burden rests heavily upon who? Upon the government to establish after notice to and hearing of the defendant that such contact with the juror was harmless to the defendant. So again, quoting Remmer, adopting it, that is presumptively prejudicial, and therefore the burden rests heavily upon the government. And then continuing down here with the highlighted part, when there is evidence of a substantive communication by a third party with a juror, the Remmer presumption applies, shifting the burden to the state to prove there is no reasonable possibility. So there's no even reasonable possibility that the improper communications influenced the verdict. That's what the state has to prove, that there's no reasonable possibility even that the improper communication influences the verdict, which means that if a juror says, again, this is just the Court of Appeals, I understand that, but let's just first understand what the Court of Appeals is saying, and then we'll move on to the Supreme Court. The Court of Appeals is saying very clearly that if there is substantive communication, meaning if there's some sort of communication which talks about the substance of the evidence by a third party with the juror, then it's presumptively prejudicial, and the state has to prove that there's no reasonable possibility even that that improper communication influenced the verdict. All right. So now this was appealed to the Supreme Court, and this is what the Supreme Court said, which Justice Toll feels, where State versus Green is saying clearly that we are not following Remmer. And because they're not following Remmer, she is not going to conduct a Remmer hearing because she doesn't believe that State versus Green is saying that Remmer applies in this situation. However, let's read it. And again, this is not really complicated legal stuff. You don't have to be a legal scholar to understand this. This is pretty straightforward. I think that's just the logical steps here will show you exactly what's going on. All right, so they bring down what happened in the Court of Appeals level, and this is what they say. Our unwillingness to categorically apply the Remmer presumption. Now, what happened in this case, just so you understand, is that a bailiff answered a juror's question about what would the judge do if they're hung. The jurors, if we're hung, what is the judge going to do? And the bailiff said, he's probably going to give you something called an Allen instruction. That's the extent of the conversation. There's no conversations about the evidence. There's no conversation about testimony. There's no conversation about exhibits. There's no conversation about lawyers and if they did a good job or not. It was just a simple question. What is the judge going to do? The bailiff said he's going to read you an Allen instruction. That was the extent of the conversation. So this is what so even though the conversation was very, very simple and mild and nothing to do with the actual substance of the evidence, the Court of Appeals felt that you still have to run through the Remmer analysis. You must, as they said, we must go through the Remmer steps. So here, so the Supreme Court here said, let's calm down a little minute, okay? This conversation, this context was so minor and really had nothing to do with anything to do with the trial that we don't have to go through the whole Remmer presumption. And this is what they say. Our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. So we are not going to categorically apply Remmer, meaning Remmer stands for the proposition that any sort of conversation, anything, you have to go through the Remmer steps, which means that the burden has to shift to the government. The government has to now prove that communication was harmless. They're saying we don't even have to start with that. We're not going to categorically apply Remmer to every single decision. Just not going to do that. Not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. Now, in Remmer itself, there was actually an attempted bribe. So here, the attempted bribery of a juror in Remmer conduct which goes to the heart of the merits of the case on trial is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never even materialized. So that was really what they are finding in State versus Green. So State versus Green is very clearly saying we are not going to apply Remmer to every conceivable situation, right? But if there would be some sort of conduct or some sort of conversation that did touch on the merits of the case, then would we apply Remmer? It's very basic steps in logic that yes, of course, State versus Green, even the Supreme Court level, is saying that we're not completely throwing Remmer in the garbage and adopting Smith versus Phillips. We're not doing that. That's not what the opinion here is saying in State versus Green. State versus Green is saying is that we're not going to categorically apply to Remmer to every single conceivable conversation, but if there is a conversation, obviously, if there's a conversation that has to do with the merits of the case, then Remmer would apply. So that is what State versus Green said. So it's very clear now to everyone here, should be, that now we understand that that what Justice Toll ruled was a mistake. It was certainly a mistake. Now, what the Murdaugh case, what the Murdaugh appeal has to prove is that there was an abuse of discretion. Abuse of discretion means an error of law. That is one of the categories to satisfy an abuse of discretion. If there was an error of law, then that's considered an abuse of discretion. Well, is this an error of law? Well, it's absolutely an error of law on how Justice Toll understood State versus Green. State versus Green is absolutely adopting Remmer. So now, is the question that we want to change, that Alex Murdaugh's team wants to change the law in South Carolina, and they want South Carolina to go in conformity with the federal law? No. They're not asking the Supreme Court to make a new ruling that we're overruling and changing the law in South Carolina, and now we're going to conform with the federal standard. That's not what they're doing. What all the Alex Murdaugh team is saying is that follow State versus Green. State versus Green already said that we follow Remmer. This was already decided. We're not asking the Supreme Court now to make a new ruling to overrule anything. All we're saying is, look what you guys said in State versus Green, and State versus Green very clearly said that Remmer applies. So if Remmer applies, then this whole hearing was done wrong, and the hearing has to be done again, or we already had the hearing. The Supreme Court already can see that there's been no presumption that was overcome by the state. The state did not overcome that presumption. And in fact, a second part of this appeal is the fact that even if we were to erroneously apply the wrong standard here, which is Smith versus Phillips, which is that the defendant has to prove actual bias, well, they did do that because one of the jurors said, Juror Z said that she came to a guilty verdict because of that tampering. That's what she said. Now, she was presented with an affidavit, and there were some questions about how she was asked about that affidavit, because in the affidavit, it seemed that she was only said that she came to the guilty verdict because she was pressured by some of the other jurors. So which one is it? But she said under oath that the reason why she came to that decision, so it was because of the jury tampering. So is there any possibility, as we said, we quoted from that Court of Appeals case in State versus Green, is there any possibility that it was because of the jury tampering? Yes. So once we establish that, that is the two levels of the two main arguments by the Alex Murdaugh legal team. Number one is that Justice Toll just simply completely misunderstood State versus Green, and she applied the wrong standard. That's number one. Number two, even in her own made-up standard, which is not how the State versus Green case goes, which is not the jurisprudence of South Carolina, even working with her standard, they still proved prejudice. They proved bias by that juror saying under oath that that's why she voted guilty. So those are essentially the two strongest arguments in these moving papers, in the appellants, in the appeal papers. And I just want to read for you the last part of their motion, because this really, I said motion, their appeal, their brief. This has nothing to do with whether you feel Alex Murdaugh is guilty or not. Hey, he can be as guilty as sin. And most people believe that. That's not the question here. The question here is whether the process was fair. The process has to be fair, irrespective of how terrible of a human being you are. You can be the worst person in the world. If you live in America, you deserve certain process, a certain fair process. And we're not going to take that process away from anybody, no matter how bad of a person you are, no matter how guilty we think you are, no matter how much we feel the evidence is weighing against you anyway. It doesn't matter. Everybody in this country deserves fair process, due process. And the minute that we take that away from somebody who we feel doesn't deserve it, it's a very slippery slope. It's not something that we want to do. So this is what the last paragraph of the appeal papers says. The public rightly sees Mr. Murdaugh's downfall as an expose of privilege and corruption in South Carolina's legal system, and the citizens of South Carolina need more from this case than confirmation of their own social media-fed ideas about the details of a crime they did not witness. They need to see that their legal system actually works. Satisfying public desire to see a hated man punished is not why we have a legal system. If Mr. Murdaugh is to be convicted of murder, the citizens of South Carolina need to see him convicted by a process they would agree is fair if they were the defendants. No reasonable man would agree, if he were on trial for his life, that having the clerk of court secretly advocate against him in the jury room so she can sell books about his conviction would be a fair trial. Providing Mr. Murdaugh with the fair trial that every citizen of South Carolina will expect for himself is necessary to assure all that no one, powerful or humble, innocent or guilty, hated or beloved, is prescribed from due process and the equal protection of the law. It's a great way to end their brief, and really that's what this is all about. This has nothing to do with whether we feel Alex Murdaugh is guilty or not. It doesn't matter how strong we feel the evidence is. The process has to be fair. And if Becky Hill was there, what this juror testified to under oath, trying to convince this juror that she should vote guilty, if that's what happened, and under United States versus, quite frankly, even Smith versus Phillips, where they were both proved, then Alex Murdaugh needs to have a new trial. And that's all that's to it. So this is going up to the Supreme Court. And my call on this is, if they follow State versus Green and they actually read it and they understand it, they read the Court of Appeals decision and they read the Supreme Court decision and they follow State versus Green, then they will follow Remmer. If they follow Remmer, then they will most likely order a new trial. Now, the Supreme Court can say, we're not going to follow State versus Green. We are going to run our own analysis, and maybe they will agree with Smith versus Phillips. And if they agree with Smith versus Phillips, then there's more room that maybe they'll say, well, you didn't really prove bias. Although I think that there's a strong argument to show that actual bias was proven here, as one of the jurors said explicitly under oath, that is the reason that she came to a guilty verdict. So I think that this appeal is very strong. And again, this has nothing to do, I have absolutely zero opinion or nothing to do with whether I feel Alex Murdaugh is guilty or not. This has nothing to do with it. This has to do with the process. And it seems from what happened, and we've been following the jury, this jury tampering hearings and evidence and all of that, we've been following it. It seems to me that a new trial has to be ordered. That's just what it seems. So we will see what the Supreme Court is going to do with this, but it's an interesting legal issue, and we will be following it as it goes along. So that's it for now. If you haven't yet, please subscribe, like, and we will see you next time.